So where we have here an unopposed motion to dismiss, what interest does the district judge have in continuing to scrutinize the dismissal of a prosecution? What is the district judge seeking to vindicate on rehearing and with the inquiries that, have been represented will be made below?
The rehearing, Your Honor, is meant to protect the process and the mandamus standard, because under the panel's decision, although written to be fact-specific, could open the floodgates to other people who are unhappy with a district court not ruling on a motion, thinking that they know what the answer should be, that the answer is clear from the case law or the precedent, and moving to mandamus a district court whenever they think they're in that position. So it's broader than just this particular Rule 48A issue.
But so a district judge has a right to litigate on behalf of legal standards generally? Does that make him a party to this case? Does it make him a freewheeling amicus? I mean, what precisely is the judge's interest in this? Any more than there would be in any case where the panel issues an opinion where a district judge may disagree with the Court of Appeals legal analysis.
He doesn't have a right to litigate or is not a party, Your Honor. This court made him a respondent. What that means for purpose of mandamus, I don't think is totally clear, but the court ordered
this
him
court
to
did not order him to respond. He appealed. Now, remember, you had the writ of mandamus. He then appointed his own attorney. He didn't like the Court of Appeals decision, the 3-judge panel, and he appealed en banc. So the court has made him a party. I mean, I don't really know which way Beth Wilkinson wants to cut it. That it doesn't really matter to me. The way the statute reads doesn't say if the court makes you a party, if you yourself made yourself a party. It says if you're a party, you're disqualified.
Well, of course.
So I don't care about her reasoning,
Andy,
really, her bizarre reasoning there.
That was a little bit of a bizarre way of getting there, but at the end result, Jordan's exactly right. It's the same thing.
She just said it.
She just said it. He's a party. How he became a party was really his own actions, but he's a party. Thus,
he is a party.
He has to be disqualified at a minimum.
Well, she made the admission. She confessed the fact that he is a respondent in the case, whether he was made a respondent in the case by the appellate tribunal or whether he did it himself is immaterial. And I don't think he was made a respondent by the appellate court. He made himself a petitioner and an intervener and a litigant. Well, that falls squarely within the prohibition of 28 U.S.C. 455. You're a litigant. You can't be part of the process. You cannot be the judge and the litigant at the same time. This is not appropriate under the law.